Hello, everyone. How's it going? This is immigration attorney Momita. I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind tonight. Thank you so much for joining me. It is my pleasure to be here and to help you with your immigration situation. If you have been watching me for a long time, thank you for following. Thank you for watching. To all of my clients and my followers out there. If you don't know who I am, my name is Momita Rahman, and I am an immigration attorney. I have been practicing immigration law for the past 13 years, almost 14, and it is my pleasure to do the work that I do because I believe that immigrants make America great already. Thank you so much for joining. I'm going to go ahead and answer as many questions live that I can in the time that I have tonight. So if you are concerned about something, go ahead and pop your question in the box below, and I'll do my best to answer as many questions live that I can in the time that I have tonight. So I want to start off with a special question today. And my question is for those of you out there who have a 2-year green card. Do you have a 2-year residency card that you got with your spouse, but your spouse is no longer willing to help you renew your green card so that you can get your 10-year card? Is your spouse refusing to go to the interview with you? And if they are, what options do you have so that you can continue your green card application, so that you can continue to secure a 10-year green card and residency and be free from deportation? So here is the thing. If you have filed for a green card through your marriage, sometimes that's not the only thing that you have to do, because when you get your green card through marriage, you will usually get a 2-year residency card if you have not reached 2 years of wedding anniversary by the time that you get approved. So what the government does in those situations is that they will issue you only a 2-year residency card, which means that you have to file to extend it or to renew it before the expiration date. But what happens if you have been struggling in your marriage and it was already hard enough to get your 2-year residency card, but now that you've gotten your 2-year residency card, your marriage is falling apart and you can no longer hold on. If you can no longer hold on because what you're suffering, what you're struggling in your marriage is difficult, or more often than not, maybe your husband or your wife says that they're going to divorce you, or you separate, or they move out, or they tell you that they're not going to help you with your immigration case. If that is happening to you, I want you to not worry, because you can actually file for your I-751 removal of conditions application by yourself. And believe it or not, you don't have to continue relying on your spouse in order for you to keep continuing to secure your immigration future. You could actually file for a waiver based upon divorce, or even if you have suffered in your marriage, you can file for something called an extreme cruelty and battery waiver. And many people don't believe, and they don't understand, that you can actually get your case approved without suffering any sort of physical abuse. What happens if your spouse is not physically harming you? However, they are saying that you only married me for my green card, or I'm not going to help you, or you only got this because of me, and I'm not going to help you any longer. Well, if these things are happening to you, usually these are manipulative and manipulation tactics designed to induce guilt and also designed to control you and your life. And if it's happening to you, then you may be the victim of emotional abuse and you may qualify for this waiver. So the bottom line is that you should not wait until the very last minute. You shouldn't wait until your card expires to explore what opportunities you have to renew your 2-year green card. You can actually file this application a lot sooner. You can file it well before your card expires. And because this application does take so long, my advice would be to actually find out whether you qualify, find out whether you can do it, and to file it ASAP, okay? So call our office at 212-248-7907. Hello and Happy New Year to everybody who's watching as well. Thank you for following me. Thank you for sharing my lives. Hello, Ashlyn. Hello, Ashlyn. Nice to see you. Deshaun, Happy New Year to you. Mary, Happy New Year. Andrew Lopez is asking how long does a T visa take in your office? Andrew, usually it takes us average about 6 months to prepare the case because there are a lot of steps that we have to take when you file a T visa, including reporting with law enforcement agencies regarding your case. And then once it's filed, we are seeing that USCIS is taking an average of 1.5 years to process your T visa case. Thank you for asking. Juhi Gurung is asking, if a person is filing for permanent residency adjustment of status for their parent who lives in the U.S., when we file for concurrent I-130 and an I-485, do they file from the petitioner's or beneficiary's address? From Juhi Gurung. Juhi, thank you for your question. So this is a good question. When you're filing an I-130/I-485, the case is actually going to be controlled by the jurisdiction of the case is actually going to be on the I-485 on the beneficiary's application. That's actually what is going to control the case. Is it possible for me to start the process with my legal issues ongoing? From Ken Io. Okay, Ken Io is asking, hello, Mamita. I got married recently. My wife is an American citizen, and I want to start my process for a green card before my O1 visa is due in a couple of months. The case is that I have legal issues. Is it possible for me to start the process with my legal issues ongoing? Kenny Oyo. Kenny Oyo, when you say that you have legal issues, I'm assuming, I'm just going to take a wild guess and assume that it might be criminal issues. And can you start your immigration case? Can you file your immigration case if you have an ongoing criminal issue? And the answer is yes, maybe, perhaps, because usually when you have a criminal issue, you want to get that resolved before you file for anything. And the reason for this is that immigration themselves is going to want to know exactly what happens, and they will usually decline to make a decision on your case until your criminal issue is resolved. So if you do have an ongoing criminal case, we need to see how that plays out. We need to see what the final result is before knowing exactly how it's going to affect your case. That is my response. Let's see. My husband applied for residency and it got denied. He had a deportation from 2018. He did not know about. What can he do now? From Julissa. Julissa, thank you for your question. I'm so sorry to hear that your husband's case got denied. So here's the thing. The surprising fact is that there are a lot of people out there who might actually have what is called an in absentia order of removal, which is basically a deportation order that was given by the court in your absence. So you're basically not there. And what are some of the reasons why somebody may end up getting an in absentia order of removal? Well, number one, the court might send you a notice of a hearing or a notice to appear, and they don't have your correct address. Two, sometimes they never send these things out, or they might send it to your lawyer and your lawyer doesn't give it to you. Or three, you may have had some really bad situation that prevented you from going to court on that date. So if you're not physically in court when you have a removal hearing, the judge will issue what is called an in absentia order of removal. So if you do have that and you filed for a green card with your spouse and it got denied, what options do you have? Well, Julissa, first of all, we have to, at the very least, address the removal order. So if your husband has an in absentia order of removal, then we actually have to go to the court and we have to ask to reopen that, and we have to give them a good reason why the in absentia order happened in the first place and ask them to reopen the case. And hopefully at that point, maybe we can get the case dismissed. Maybe we can ask the judge, we can show hey, look, judge, this person is actually married to a U.S. citizen and they have the option of legalizing their status in the U.S., but we can't because we have this order. Can you please do something about it? So basically that's a simplified way of explaining what happens in court. But if you have an order removal, that's what we have to do. And usually it takes some time, because once the case is closed and the order has been issued, it's kind of archived. So we have to fight a little bit longer and harder to get it reopened. But Julissa, you can give us a call, 212-248-7907. I'd love to see if we can help with the case. Vasquez, Rayana, do you offer free consultations? Rayana, we don't, but just call us, 212-248-7907, and see if we can, explain what your situation is. Can your son, a green card holder, file for his mother who overstayed in the US from Black Beauty? Black Beauty, unfortunately, no. Now, here's the thing. If you have if you have your green card and you want to sponsor your parent who needs residency, you can't really do that anyway until you're a US citizen. But moreover, if you're a green card holder, your parent is not considered an immediate relative. So, and for anyone who's not an immediate relative, you cannot have any unlawful presence in order to adjust your status inside the United States. If you are a preference category relative, you actually have to do either waivers or basically wait for your spouse to become a citizen before you can fix that way. Floor, thank you for the follow. Michelle Black, if your husband has been abusing you, I'm really sorry about that. My advice to you is to get out of that marriage. I applied for VAL and I got my work permit. I'm hoping to get my green card soon. Floor, I hope you will get it soon too. Let's see. Can a VAWA case be faster with an approved I-130 from Diara Daddy Girl? Diara, no, the I-130 doesn't really make much of a difference, especially if your spouse is already a U.S. citizen. Chani, if you sent us a DM, here's my advice to those of you who are watching me on Instagram. Please don't send us a DM. We have a really hard time responding to DMs. We're only allowed to respond to a small number of DMs because of all these bans that TikTok keeps giving us. If you want to work with us, if you want to find out if you qualify for something, call us. Pick up the phone and call us at 212-248-7907. That is the fastest way to get to a live person. We may not be able to respond to your DMs. Now, the other way to try to get in touch with us is to go to our website and to send us a message through our website, which also takes us some time to get through because we do get hundreds of messages a day. So I really want to be able to help as many people as I can. And my request to you is that if you're looking to work with us, if you're looking to have an appointment, call us at 212-248-7907. I have a pending asylum case and I have an upcoming court this June and I got married before 2 months. What do you recommend me to do? And how long is the process until I get my green card? From Sharial Hajay. So that's a good question. What happens if you have a court process and you got married to a U.S. citizen, but you have your upcoming court dates? Well, here's the thing. That by itself doesn't mean that your case is going to be stopped, but you can try to negotiate with DHS counsel. You can let the court know that you're now married and you're looking to convert your case to that of a green card case with your spouse, and you can see what options work best for the court that way. I have been receiving prima facie continuously for 3 times. Is that a good sign that my case is going the right direction from all-in-one events? All-in-one, yeah, I think that's definitely a good sign. But you still have to, if you've gotten 3 prima facies, your case has been pending for at least 3 years. So hopefully you get a decision soon. I have an NTA, but my case is not in the EOIR system. What can I do to put my case in EOIR? From Mikwa. Mikwa, do you want your case to be in EOIR? I mean, that just basically means that you'll be in removal proceedings. You can contact ICE and ask them to enter the NTA. But I don't really have any advice about that because usually my business is I'm trying to keep people out of EOIR. Let's see. How long is the process for a U.S. citizen to fix for the husband who came illegally, who came 10 years ago from Yari? Yari, that is a really good question. Now, how can you help your spouse fix their status if they entered through the border, if they entered through the desert illegally, and now you want to help them fix? Well, there's a few different things that we can look at, but at the end of the day, if you are a U.S. citizen, it may not, either your spouse has to leave the U.S. or we will look for some options to help them fix their status inside the United States. Yari, I would say call us at 212-248-7907 so we can ask some questions to see what might be the possibilities. My girlfriend has asilo político afirmativo en espera aprobación working and will file taxes. What qualifications should the tax preparer have? From Xavier Palenque. Xavier, good question. For those of you who are filing taxes for the very first time, what qualifications should your accountant have? Well, that's a hard question for me to answer, but one thing that I look for is someone who has a good reputation and who's been doing it for a long time. You can also pay a little bit extra to go to someone who's like a CPA or an actual accountant to help prepare your taxes. They'll charge more, but they have that training and that background, and they're not just somebody, who says that they prepare tax forms. So that's what I would recommend that you look for. Are they still waiving interviews for spouses that are married to U.S. citizens from Real One? Real One, yeah, we've definitely been getting a lot of waivers. Other than parents and children under 21, can holders of siblings of U.S. citizen apply for change of status while being in the U.S. and tourist visa? Sana Akan, it's a little bit of a complicated question, which I can't quite answer right now because it sounds like there's a lot going on in your situation. And I just want to say that, okay, let me decipher your question, Sana. So can a sibling of a U.S. citizen apply to change your status after staying in the U.S. for more than 90 days? Yes and no. So here's the thing. If you are the sibling of a U.S. citizen, if you're the brother or sister of a U.S. citizen and you happen to be in the U.S. on your visit visa and you want to stay, right? You want to stay and you want to apply for your green card. Can you do that? Well, you can, but you probably won't get approved because the green cards for siblings of U.S. citizens is taking 10 to 15 years, and it's taking so long that your visit visa will long expire before that ever becomes current. And that means that if you end up staying here while you wait for your visa to become current, you're going to accrue unlawful presence. And when you have unlawful presence, you will require a waiver for that unlawful presence, and you will need to leave the United States as well. So it's not really a good solution to stay in the United States. Usually what I recommend is to at least file the I-130 and then go back and live your lives out in your country. And then when it's done, to come here and fix. Let's see. Harsh Patania, you need a consultation, my friend. If your wife has accused you of domestic violence, you definitely should not travel. You've basically been accused of a crime. You don't want to take a chance that the Border Patrol is going to be asking you questions about that. And you can call our office if you, you need a criminal attorney is honestly what you need first if you have been charged with domestic violence. Ramesh Hines is asking, I just want to know if you start your case in one state, but then you move to another before your case gets approved, what can you do? Well, first of all, anytime you have already filed your paperwork with immigration, but then you move, it is your obligation to make sure that your address is updated with immigration. Sometimes moving different states should cause your case to be transferred, but immigration is really, really slow. And sometimes what will happen is that even if you move and you file the proper change of addresses, they don't update your case and your file stays in your old location. So by the time it starts moving down the line for the interview, you might get an interview notice from this other state and you have to basically do a few things to try to get that jurisdiction changed and moved around again. So it's a little bit of a hassle. But my advice is just always make sure you file your changes of addresses and make sure you keep proof that you file them in case there's ever an issue with your case. Any idea how long I-485 sits in NBC? I've not received a response for 1.5 years from Shiva Tapa. Shiva, no idea, but 1.5 years sounds like a long time. You may need to do some inquiries to check to see if it's still within the proper processing time. Lakshmi is saying, my VAWA expedite has been approved. How long does it take to receive a decision after the expedite approval? From Lakshmi, the question is really, my question is, was it your I-360 that got expedited or your I-485? Because if you have filed for VAWA and you ask for an expedite, that's just usually for the I-360, but then you still need to do a separate expedite for the I-485 because these are two separate processes. So if you expedited your I-485, then hopefully you get your decision within less than 6 months. I don't know how long it's going to take, but usually when we do expedites in our office, usually we see results in about 3 months. Is it normal to never receive EAD, only RFE for marriage based from Ursula? Ursula, that's an interesting question. I have never received an EAD. Yes, I have received EAD RFEs like for pictures and some other things. So it's not common, but it's not abnormal. VAWA approved, but I-485 denied. What are the next steps I have to take? From Jivan. Jivan, give us a call, 212-248-7907. The first step is actually to get your case analyzed, get your decision analyzed, to find out why it was denied, and then to see if we can help remedy that situation, okay? Audrey, Happy New Year to you too. Kadane, I have been in the U.S. Since for 1 month. Can I file for VAWA? From Kadane. Kadane, yes, if you qualify for VAWA, but you've only been in the U.S. for a month, that doesn't mean that you can't file. So Kadane, give me a call, 212-248-7907. Do you work with Italiano American situation? From Carla Valastro. Carla, I work with everyone across the world. Just call us. The only limitation that I have is that we don't work with all types of immigration cases, only certain types of immigration cases, such as VAWA, some affirmative asylums. I'm very picky about those cases that I take, T visas and U visas and I-751s. We're not really doing many other types of cases besides that. Can H1 status be affected if my green card based on marriage doesn't get approved from SK Patel? SK Patel, that's a great question. If you already have an H1B visa, can that be harmed by a failed marriage case? And the answer is no, because your H1B visa does not depend on your marriage case. And as long as you still continue to satisfy the requirements of your H1B visa, you should be totally fine. Can a U.S. citizen file for mom that left to Mexico more than 13 years ago? From Araceli. Araceli, absolutely, absolutely. If your mom, it's been 13 years since your mom left, the only thing that I'd really, really want to know is, first of all, does your mom have any criminal convictions? If they left 13 years ago, even if your mom got the permanent bar, we can still help them come back, okay? Call us, Araceli, 212-248-7907. Lisa Ansari, how long does a green card take after work permit? It totally depends on the type of category you file under, so can't quite answer that question. If a person was taken out of the U.S. as a child and then brought back, can they apply for a green card? From Lizette. Lizette, it depends on whether they have the permanent bar. So here's the thing: the permanent bar, you can trigger the permanent bar even if you came back and forth when you were a child, even if it was against your own. You had no control over that. So really, Lizette, what really matters is how old, when did you come into the United States? When were you taken out? And when were you brought back? That's what we have to analyze. And then once we determine whether you have the permanent bar or not, Lizette, then we can see what sort of cases you qualify for. Now, if you have the permanent bar, we work with primarily 3 case types that where people are still able to fix your status even with the permanent bar. Now, the first one is the T visa, the second is the U, and the third is the VAWA application. However, for VAWA applications, it's a lot more limited and it's a little bit harder because it's very case and fact specific on that. But Lizette, give us a call, 212-248-7907. How long is it taking to get a green card through adjustment of status versus through marriage the traditional way? From Ivan Rulfo. Ivan Rulfo, those 2 things are actually the same thing to me. Like if you get a green card through adjustment of status, okay, I see what you're asking. If you're going to do adjustment of status, you can't just do adjustment of status by yourself. You either have to do it through marriage or do it through employment, or do it because you're doing VAWA or you received T visas or a U visa. So you can't just file an adjustment of status without an underlying approval of a different case type. So if you want to file for adjustment of status and you have the option of getting married, that's probably the fastest way. Those cases are taking under 1 year right now. Elia, puede llamarnos a 212-248-7907 para agendar una cita. Soft's World, I claimed false citizenship on border. Can I apply for VAWA from Soft's World? Soft's World, that's a very good question. Can you still apply for VAWA even if you have a false claim to U.S. citizenship? And my answer is yes. You can apply for VAWA because VAWA does not necessarily require you to not have a false claim. However, the adjustment of status application will be difficult, and I may not even submit that so that I don't put you in harm's way. However, do you know the case that actually can fix a false claim? That would be the T visa and the U visa. So call us, Soft's World, 212-248-7907. I do not work with SIV process. I answer here with a tourist visa. Is there any way or program to adjust my status? I'm single and my parents are residents. Figueroa, not really. We can see if you qualify for something outside of your family. So call us at 212-248-7907. Jalal, you're being blocked. Too many flirty messages, man. Listen, guys, don't flirt with me here. I'm here to work. All right. If someone came to the U.S. with a student visa and it expired, however, this person never stopped studying, can this person fill out for green card or residence? From Richard Wayne. Richard Wayne, as I mentioned, you need to have an independent basis for this. Maciel, thank you for following. Maciel, what are my prices to get started? Maciel, call us at 212-248-7907. We first have to do an evaluation of your case to see what we can do to help you. And then based upon what you're eligible for, then we'll give you the prices after that. But our consultation fee is $150. And if we can't find a case for you, we actually will give you that money back. How long does it take for a filing to go through if my mother is filing for her son? From Andre Lee. Andre Lee, if your mother is a U.S. citizen and she's filing for a child under 21, these cases take under a year. Do you look into ESTA? My spouse's ESTA was denied. I don't do ESTA applications. How long can you stay out of the U.S. on a green card? The answer varies. You can stay anywhere from 6 months to more than that, but you might need a special permission called a reentry permit. Udayveer, thank you so much. How long does it take for a U visa, for a T visa? Udayveer, average it takes us about 6 months, 6 to 8 months to prepare that, but we're trying to move a lot faster than that. Kinjal, hello. Lolade, thank you so much. Thank you for your blessings and blessings back to you. Can I file from Mary Shane? Can I file for a T visa if I suffered from employer abuse, such as not being paid what was agreed to, not being paid for the hours worked, being threatened to have immigration called on me? From Mary Shane. Absolutely. So this sounds like, and Mary Shane is saying, I suffered from the above, but I wasn't locked in a house or office or anything, but my employer still did this to me. Wow, what a great question. So let me go over that. Can you still file for a T visa if your employer didn't pay what they said they were going to pay? They threatened to call immigration on you, but you were never locked in an office. That is such a good question, because that tells me that you out there believe that that a trafficking case is only possible if you get locked or if you get physically forced to do what the employer says, which is understandable. But really, we're not looking at physical limitations. We're looking at the mental cage that your employer creates around you, Mary, where the cage that this employer has created around you that makes you feel threatened into working. They make you feel threatened into providing your services, That is what makes it involuntary servitude, and that is what makes it trafficking. And when that happens to you, you do not need to be locked into a room to do this. You could be willingly going into that office by yourself. You could be willingly leaving that office by yourself. But really, what is it that keeps you coming back to that office day after day to do hours and hours of work that you're not being paid for and to suffer threats from your employer? It is because that employer has created a mental cage around you that creates an invisible shackle for you. So Mary Shane, call us at 212-248-7907. We would love to see how we can help you in your situation. And don't delay, okay? Can someone apply for a VAWA with a deportation from Danielle? Danielle, absolutely. And sometimes, oftentimes we can get that deportation kind of reversed and terminated. How long to give decision for the VAWA case after you submit additional evidence from Malkit? Malkit, on average, I would say it takes about 2.5 to 3 years to get a decision, no matter when you give the evidence. Barbara Boozy, if immigration gives you time until final decision and they give you 5 more months until final decision again, I don't know what the rest of the question is. Vashti, does my husband have to go back to his country to get his visa, or can he get it here? Vashti, give us a call, 212-248-7907. Now, normally a lot of people get told they have to go back to their country if they don't have a legal entry to the United States. Where that's the case, we like to look to see what other cases the client might qualify for, because I really do not like to send clients out of the United States unless that's the only option. So Vashti, give us a call, 212-248-7907. How long to get an answer for the I-130? 6 months to 2 years. It takes a long time sometimes. Chistia, my work permit and travel documents were approved in 2019, but my I-485 is still pending. Chistia, apply for renewals of your applications. This freaking guy, Jalal. What is the percentage of VAWA cases that your office has gotten approved from? Diara Daddy Girl, nearly 100%, Diara. And that's the honest truth. Sitaram, hello, my husband withdrew his petition through marriage and now it's denied, but I applied to VAWA case. What will happen? From I'm Sitaram. Sitaram, sorry to hear that your husband withdrew your case. I know that's the worst nightmare for so many of you out there, that you start this case with your spouse, get into a fight, and they want to hurt you, so they withdraw your case. If your spouse has withdrawn your case or they threaten to withdraw your case, you can file for VAWA. And what will happen if your case is already denied and you file for VAWA is basically you're starting fresh. You're starting fresh, so not much will happen besides, whatever happens on the VAWA case. Sometimes, depending on the jurisdiction that you live in, if you do have a denied marriage case, sometimes you might get a removal case started against you. So you have to watch your mail and you have to monitor everything and pay attention and call a lawyer in case you get anything in the mail. Is a police report necessary to file a T visa, or we can proceed without it? I already spoke with your staff and he mentioned about the police report from Miss Ella Pulido. Ella Pulido, what is required is we have to cooperate with law enforcement agencies and submit a report. So we do have to do that. That is a legal requirement for a T visa case. And it's not always a police report. Half the time, more than half the time, what we're doing is we're submitting reports to the Department of Labor. Sometimes we just send an email to the Attorney General's office. So there's various ways to do it, and it doesn't always require actually filing a report with the police department. So we have to do law enforcement agency reporting, but it's not necessarily a police report. So don't let that hold you back. Please, call us again so we can go over exactly what you're worried about if you're worried about that. I'd rather you go forward with your T visa case, Ella, than not do it at all, okay? Don't let that be the fear that holds you back in not filing for the T visa case, because if we think that you have a case, it's going to be a good case and we're going to file it really well for you. So Call us, Ella, 212-248-7907. All right. My husband came back illegally 17 years ago. He had a DUI back then, and he went to every class. I'm a U.S. citizen. Can I petition for him to get a green card? From Markel. Markel, if your spouse was deported and he came back illegally after that, then it's going to be difficult because he probably triggered what is called the permanent bar. So what I would recommend to you, Markel, is to call us 212-248-7907 so we could evaluate your husband's case to see what his options are, okay? All right, guys. That is all the time that I have for tonight. That is all the time that I have. Just make sure you follow me. Make sure you follow me. Make sure you share my videos. Come back again. I'm going to do my best to answer all the questions in the time that I have next. Okay. I wish you all a blessed evening. Thank you for joining me, and I'll see you again soon.